Yes, sir.
My confusion is that if these delivery boys or for that matter gas station attendants, they are employees of the employer, then employer is supposed to do employment eligibility verification also, otherwise employer is in violation of immigration laws, and most of these employees, they are paid cash, they are not paid for the books.
All right, so let's talk about the practical implications of that. So yes, you're correct. Let's say gas station attendant, could be anybody, but gas station, let's assume. They're supposed to be legitimate employees and have I-9s. Right now, the more difficult aspect of all of these things, well, I suggest publicly that we suggest that they comply with all the laws. However, the reality is if they're paid cash and they show on an envelope, which we don't advise, but if they show on an envelope that they're paying people $10 an hour for the first 40 and $15 after that, and the employee gets a copy and the employer gets a copy signed and dated as though it's their old mini ADP or whatever, payroll company you want to throw in there, at least they have proof that they have done it right. The U.S. and New York State Department of Labor right now couldn't care less if the people are legitimate, not legitimate, etc. We have a client of ours from ICE. Now it's not called ICE anymore. Now it's Homeland Security or whatever. We have a client, told the story yesterday. They have 52 employees. I remember that because it's like a deck of cards. Not in the restaurant industry. 52. They get hit by ICE, brought in, let's see your I-9s. Client of ours has been a client for a long time. They show their I-9s, we look at them, they're right, whatever, they had backup information. 3 weeks later, they come back and say, let me just tell you, of the 52 employees, 3 are legitimate, 49 are illegitimate. What was the fine for the company? 0. They had documents, as long as the documents were not Social Security cards, were not purple with pink polka dots. They had situations, it's ridiculous, but it is what it is. They had situations, they don't have to be a detective. They never asked, are these legitimate? Did you go to wherever it is? These are what they provided them. The driver's license might be from Iowa, and maybe the person never knows what Iowa is, but that's the documents. So so it is a fallacy. We hate it until, I'm a management attorney, but I think that people have, there should be some kind of, I don't know if it'll happen, but some kind of immigration reform. Probably the stock market would go to 35,000 and people can't figure it out. But I'm just saying, that's the problem of the I-9s, whatever. The biggest problem that people are going to have is the big dollars when you're talking about that. All right, I have to talk about spread of hours too. Yes.
You talked about agencies cooperating. If there's an audit on I-9 and they find that there's a whole bunch of people that are illegal, and the documentation is not proper, do they then cross-reference that to the Department of Labor?
Well, first of all, the Department of Labor is the one the wage and hour people are the Department of Labor. There are all these different, unemployment is the Department of Labor, whatever, but we have not found. There are going to be task forces. That stuff is coming more. And that's what Spitzer ran on or whatever. Remember, he was governor for an hour and a half. But I'm just saying that the point is that right now, today, we have not seen the U.S. Department of Labor, were there yesterday, New York State Department of Labor, do not even look at I-9s. Nobody looks at the I-9s. The U.S. Department of Labor has the jurisdiction to look at the I-9s. They're not looking at the I-9s right now. So nobody's calling anybody. They haven't called the IRS. They're not calling that. They have not. Whether that's going to happen tomorrow, I don't know. But that's the reality. Okay? Yes, sir.
When it comes to protecting individuals from personal liability,
yes.
The corporate veil or the corporate shield is not effective?
No. It's not corporate law.
Not for wage and hour.
Wage and hour, no such thing as the corporate shield. They pierce the corporate veil in wage and hour law. Welcome to our life. So it's different from just about anything that you have. There's a question, sir. Be right with you. Yes, ma'am.
There's a sleeper issue on wage and hour, and I'm not sure what the status of it is, the salary floor, which the Obama administration has been talking for about a year about raising. I was wondering what the status of it is.
Okay.
Right now, whether they've made a decision on that or what the numbers might be.
It's somewhat irrelevant because federally it's $455. I didn't mention that before. Thank you for raising that. It's $455 federally. But in New York State, I'm going to get this right now. You can show, I'm going to show you. It's $656.25 going up to $675. Yeah, Jasmine educated me again. Good job. But $656.25. So when you're getting these things in the wake up for the new changes. You know, if it goes to $600, irrelevant for New York.
I think the federal DOL is talking about numbers anywhere from 50,000 to 65,000.
They may be talking about that. I've heard a lot of different stuff, but I don't think it's going to wind up there. But we don't know. Right now, we have not seen what that's happened. Nothing has really happened. But if you take about, basically you're almost at at $35,000. I would say $656.25 or $675. That's the same times 52 is close to 35 grand. So that's where it is that we have to worry about it for now. Question, yes, ma'am.
So coming from the insurance world, even if you do have an employment practices policy, wage and hour is often excluded, and you might not even get defense costs. So
right.
That's the other thing. When you say settle, oh boy, you should settle.
Yeah. So thank you for raising that. We were going to talk about EPLI. People should have, every employer should have an EPLI policy. What's an EPLI policy? EPLI policy, this is going to go to the discrimination end, and we're jumping a little, but we're getting through everything. The discrimination aspect is that anybody can make a claim. New York State Division of Human Rights, New York City Commission of Human Rights, EEOC, or the local Nassau or Suffolk agencies, which are under that situation. And so they're usually reasonable as far as costs are concerned. Everybody should have that. It's a double-edged sword, though. Let's talk about wage and hour. Some wage and hour, some insurance companies are writing some policies for defense costs only. Some of these things, don't. What is not talked about in the EPLI policy, and we make sure that we talk about the EPLI policy, that they understand that punitive damages are not covered. Punitive damage, which is where the real dollars are. So we had one client, again, new client, came in, hired a director of marketing. Woman told the man that she was pregnant. He went berserk and said, "I don't care," and whatever. He fired her, did all kinds of crazy stuff, and says, "I don't care, I have insurance." Well, it became punitive. The punitive damage is not covered by insurance, whatever. Now, representing management for a long, long, long time, and we, however, have seen, although the EPLI policies are something we recommend, what's happened is with a lot of plaintiffs' attorneys, knowing that many companies have EPLI policies, or EPL policies, whatever, are filing cases that maybe shouldn't have necessarily been filed, either at the State Division or EEOC, et cetera. And the insurance companies, good, bad, or indifferent, many times blink. They want to say, look, let's get rid of it for X dollars nuisance value. So some of the the fact that there's EPLI policies now, on some issues, have actually raised the number of cases that we've seen. So when I say it's a double-edged sword, it's a double-edged sword. But something that we recommend, and I guess that's for... Frankel lawyers and stuff like that to go speak to them afterwards, et cetera. They'll get a chance to do that. All right. So I think we did the wage and, for the most part, wage and hour update. We talked about interns. We can talk about that a little bit more if not, but I think, hello, my name is intern. We gave the two cases. We're waiting for the Second Circuit. If you give us your cards or something afterwards, if we get notification, once we get notification, you'll put you on an email blast list and get that. Yes, ma'am.
Two questions on interns.
Yes.
On interns and unemployment.
Yes.
An intern gets to unemployment, gets to the end of phase of the law firm versus citizen conversation, and are they then entitled to unemployment at the end of their particular, if they come to the end of law school? And the second question is that with interns, does the employer have to have a program? In other words, some kid comes off the street, hey, I'd like an internship. Does that person then qualify for an internship, or do you have to have some legitimacy, some background, etc.?
Well, that's the second question. You want to take that? You want to take both of them?
I can take both. So if the intern is a paid intern, then yes, they can go for unemployment. If they're an unpaid intern, it's likely that unemployment's going to find that they should have been paid.
This is paid. There's no question.
There's a paid, so yes, they qualify for unemployment. They're an employee.
You're really talking about, for the most part, peanuts as far as dollars are concerned. I mean, it is what it is. It's not a big cost to that, but everybody goes, oh, they do that. Sorry. Yes.
With regard to having a program in place, if you're a profit company, it's a good idea because the Department of Labor, courts, everyone's finding that interns should be considered employees and paid. And it's very, very tough now to be considered a legitimate unpaid intern. You need to receive college credit.
It has nothing to do with pay or anything. They're definitely paid. The question is, if the intern gets to the end of their internship
Right.
with the school, are they then eligible for unemployment afterwards, or is it because they will be getting credits, they are not eligible for unemployment? That's the question.
If they're an employee of the company, they're entitled to unemployment, which as an intern who's getting paid, they're an employee of the company.
Maybe unfair, but that's where we think it's going. Sharon?
How long does somebody have to work to get?
Okay.
That's the thing, yeah, there's the...
Right, so the question, that's another aspect. The eligibility requirements. I want to say 20, it's 20 or 26 within a 52-week time period. I don't remember if it's 20 or 26 weeks. So if the person is only working 8 weeks for you or your company, then they may, right, if they haven't worked at any time during that time period, they'd be ineligible because they haven't worked the legitimate foundation of 20 or 26 weeks, whatever it is. Yeah. Okay? Great question. Thank you, Shari. That was excellent. Okay, where are we? We're here in Hofstra.
Interns.
Interns we've done. Okay, interns we've done. Now, earned sick time credit. Here's where everybody falls apart. If you're a Long Island, you represent Long Island company, but your Long Island company does some service or sales or something in Manhattan, that person is entitled, even though it's a Long Island company, to the New York City Sick Time Act. Now, many people may not have that as well anyway, but you may. So, what do you have to do? You have to provide 1 hour of paid sick time for every 30 hours worked. Okay? Jasmine has the things up there. It starts after 120 days of employment, et cetera, et cetera. It's up to 5 days. The pragmatic loophole to this, and we'll sort of work it backwards, is that if somebody has PTO days or things like that, works. If you allow vacation to be used as sick time, hey, you call in, or the person's child is sick, or things like that. That's up to 5 days again, 5 days depending upon number of hours that they work. So somebody goes and works in Manhattan or the 5 boroughs, and they go work. Let me do so the math is good. So they work 100. Let's assume 120 hours for the year in Manhattan. You don't have any sick leave policy other than that. Under this, they would be entitled to 4 hours of sick because they've worked 120 divided by 30 is 4 hours of paid sick time. Now, somebody has 5, say, now you have New York City, or I shouldn't say that, 5 borough clients. You have 5 borough clients, and you say, okay, they now have to pay 5 sick days. Do you have to pay them out at the end of the year? The answer is no. What do we recommend? We recommend you roll them over. Oh, what do you have to do rolling them over? Well, let's assume the person has taken 2 days and has 3 days to be rolled over. Do you now have 8 for the next calendar year? The answer is no. It's a total of 5. So technically, it's really a use it or lose it situation. And so now they've taken 2 in 2015. They'll have only 5 available in 2016. So if they take all 5, it's a total of 7 as opposed to 10 in the 2 years. Follow?
But you don't have to pay employees for unused sick time?
Do not have to pay employees for unused sick time.
If you have a rollover policy.
If you don't have a rollover policy?
You have to have, if you don't have a policy, then it's earned and they have to be paid. You have to have a written policy that has a rollover.
Right, and there's a requirement under New York State law to have vacation policy and a commission policy in writing. You have to have those things. Your clients need to have those things in writing. If you don't have a commission policy, that needs to be in writing as well. I don't think we have that on our slides.
So if the employer already offers PTO or vacation, the policy has to say that it can also be used for sick time. If it just says vacation, then they're entitled to 5 additional sick days.
Okay.
It has to say sick time.
8 personal sick days.
If it has a sick in there, then it's okay as long as it's accrued at the same rate.
Right. Okay?
Or better.
Or better, right. Good. Yes, question.
So let me clarify. So if the employer is located in Long Island.
Yes.
But I have a client that's in Manhattan.
Yes.
then we still have to offer this to our employees.
Yes.
Who are going to Manhattan, but it's based on the hours that they're actually working in Manhattan.
Right. So let's assume.
You know, because let's say, so you have an attorney.
Right.
Well, yeah.
Yes.
They're entitled to the 5 paid
So
sick
in my
days.
example, if they worked 100, I just made the arithmetic easy for myself. When you calculate, I'm sorry?
The secretary that works on Long Island.
No.
No relationship.
No.
No, it's the employee who's actually working in any of the 5 boroughs. And whatever, if they spend half their time in Long Island, half in New York City, it's the amount of time they're spending in the city.
But if you had a city office, you have a city office, and you have a Long Island office, a city office. You have a city office with an administrative person, secretary in there, and you have a Long Island person. The Long Island person is not entitled to any sick days under that fact pattern, and the New York City person will be entitled to 5 sick days. Yes.
That
Yes.
applies to professionals and non.
Yes,
First, everybody. Yeah, right
For
question.
Long Island.
not independent contractors.
Long Island employees are not entitled to this unless they are doing work in the 5 boroughs. But that's the slip up. We haven't seen really much court cases. Brand
Not
new.
yet, but
All right, we have employees can use sick leave for many reasons: mental, physical illness, injury, et cetera, et cetera. Let's go on to the next. We talked about what unused. We talked about potential liabilities. I mean, you have in your packet. I mean, there's stuff about retaliation, and we haven't really seen that. We've got another, less than 10 minutes. So let's go on to. We talked about EPLI. All right, we're going to spend just a few minutes on this. This is one of the hottest, insane topics that we have. We've got about 8 minutes to go, so we're good, I think. 19 minutes to go. Okay, as I said, we have 8 plus 11 minutes to go. 19 minutes, I didn't know. Okay, good. So we got time now. We're trying to rush a little bit. All right, what's happening now with non-union companies? All right, the National Labor Relations Board is, as you may know, there are fewer and fewer unions that are involved. There are plenty of unions, but it's the National Labor Relations Board and National Labor Relations Act. Please recognize they're not called the National Management Relations Board or National Management Relations Act. So what is happening, again, this is just brand new, scratching the surface, is that the National Labor Relations Board is taking the positions on handbooks and social media that even for non-union employers, they could wind up violating the National Labor Relations Act. And if determinations are viewed as though they're violative of Section 7 of the Act, which we'll talk about in a second, your clients can be subject to say, how in the world did I wind up, I'm a non-union company, wind up before the National Labor Relations Act and owe back pay to John Jones or Mary Smith on this thing? Great question. Come along for the ride. The nightmare continues. So, I like that actually. All right, so Section 7, let's take a couple of minutes. We do have the time for this, so let's read it. And this is what Section 7 is. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and as Jasmine has bolded, here we go, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. Concerted activities for other mutual aid or protection is where we have to be. And I shall also have the right to refrain from activities, et cetera, et cetera. All right. So let's go. Jasmine, you want to go and follow that up for me, if you wouldn't mind?
okay, so if you have rules in your handbook or social media, whatever, if you have rules that reasonably tend to chill an employee's exercise of their Section 7 rights to engage in other concerted activities for the purpose or mutual aid or protection of themselves and other employees, then that can be found to be unlawful. And usually a law is not explicitly violating the right, so there's a 3-part test, and that's reasonably construed the language. The employee reasonably construed the language to prohibit their rights or under Section 7. The rule was in response to a Section 7 activity, or the rule has been applied to restrict Section 7 rights.
Okay. So, regardless of union or non-union, here we go. Employers should review their policies so you have confidentiality and non-disclosure. Loyalty, professionalism, solicitation, distribution, conduct, social media, at will, email, stealing, and dress code. Before we go, I guess we'll get to, I want to make sure we get to Abercrombie and Fitch.
Yeah, we'll get to
We'll get to that. So I want to make sure that's new. All right. Let's talk about reality. What's Section 7? It's a lot of gobbledygook. What does it mean from a practical standpoint? And we'll go through it.
Basically, you can't chill someone's right to talk about the terms and conditions of their employment. That's
including wages.
Yes.
So, and it has to be concerted, meaning more than one. So if Jasmine says to me, hey, you're not paying me enough, you're a terrible employer, or you can write all these things down if you want, a terrible employer and all these other things, that's not protected. It's not concerted. It's just herself. If she and another attorney say to me, or say on social media, or say on Facebook, or Twitter, or anything else, hey, Franklin, Gringer, and Cohen is a horrific place to work. They don't pay enough. They don't do this. They don't do that. We do seminars, and I get to only speak 17% of the time. It's a terrible thing, and all thing, and we cannot legally then terminate Jasmine, which we'd never do anyway, Jasmine and the other associate, because they are going and doing that. It was never there before. Yes, sir.
Can't you just terminate them because at will and just not give a reason?
No.
Well,
no, because you can.
Then they'll file something with the NLRB and say this is why I was fired, and they'll have the proof if it's on social media.
Yeah, and one thing we didn't cover really is that what really is important, and we sort of do a different kind of seminar on we really haven't touched about discrimination cases. We're going to talk about Abercrombie and Fitch, which is a new one, but really for your clients, in real estate, they say what? Location, location, location. In our business, we say documentation, documentation, documentation. There's no such thing as a verbal warning. You remember one thing that I talked 100 miles an hour and a lot? There's no such thing as a verbal warning. People don't like to give written warnings, present company included, but it has to be done so that when somebody makes a claim and said, hey, I worked for the company for 3 years, I was a great employee, I had no warning letters in my file, I had anything else, et cetera, et cetera. So I might as well do this, a little out of order for a second. Yes, sir.
So my other question is, to get swept into this NLRA,
yes.
You have to have a certain number of employees?
The
No.
Act, I think, covers everybody, right?
I think the Act covers anyone, so I think if an employer has themselves and plus 2, I think that's what it is. It would have to be, yes, it would have to be at least 2. 5?
It's an independent interstate commerce test. I think you have to have more than $50,000 in interstate commerce.
Yeah.
It's just about
Everybody.
Right, yes. And I think the gross revenue is $500,000. But the issue is then that, there is, believe it or not, a New York State Labor Relations Board for those people for less. So yes.
On this thing, the NLRA,
yes.
A standard employment agreement or an at-will letter, and they have to sign a confidentiality agreement.
Yes.
With restrictive covenants, that confidentiality agreement needs to have those proper, has to be properly drafted.
Correct.
So it's not too broad.
Yes.
Otherwise, you can't enforce the confidentiality clause.
That's correct and right, because the issue is there's got to be language that's got to be added. There should not. There should not.
Yeah, there should be a proviso, but even that, it can't be, I'm sorry, I'm trying to find that slide. It can't be too broad. It should be at the end of each section that it relates to. If I could find, is this it? There we go.
Proviso. Yeah.
Yeah, it has to be narrow enough. It has to be at the end of each section that it could apply to. And if in the past they disregarded it, then it's not going to count.
So, an example, you have it. It's in your packet near the end, I guess. For example, nothing in this handbook shall be interpreted as prohibiting or limiting an employee's right to engage in Section 7 activities. no employee will be disciplined or adversely impacted by their engagement in Section 7 activities. So going back, sir, to your client, to your statement, in a confidentiality agreement, nothing in this confidentiality agreement shall be interpreted as prohibited or limiting an employee's right to engage in Section 7 activities. So although it's confidential technically about what they and the other people make, it's something that, you're really talking about, and that may be confidential. They can talk about their wages, hours, working conditions on that. It's a great question. Thank you.
If you're in a jurisdiction that requires a verification code, please write the following code word down. CARD. C-A-R-D. CARD.
Yes, sir. Yes, Josh.
Going back to the verbal warning.
Yes.
I've gotten in document production from defendants, memos to the file, emails indicating that there was a verbal, something said to the employee about their conduct.
And then the employee says, from the management standpoint, the employee says, I don't know what they're talking about, it never happened. All right? So for the again, as the employer is the one responsible. Yes, from the employer standpoint, it's better than nothing.
So it is relevant and it is...
It's relevant, but the question is going to be, if the employee says, yes, that did happen, that did happen, then it's considered that. If it did, it doesn't have to, it could be by email, a warning letter. But the warning letter should be, there's a written warning letter. Dear Joe, this shall serve as a formal warning letter. Let's do attendance. On a review of your attendance record since January 1, 2015, indicates you've been absent 9 times, late 17 times, and left 12 times early. This misconduct will not be condoned. Should this or any other misconduct occur in the future, you'll be subject to severe disciplinary action, which may include discharge. So you tell them it's a formal warning letter. You tell them this is what they've done wrong. You say it's not to be tolerated, and then we always say this or anything else. So they say, all you did was warn me about my attendance. The fact that I cursed out my supervisor, I wasn't born for that. Question, yes, sir.
I was just going to say that in UI cases, many times you will find that the first written warning will refer to prior verbal warnings, and they will have the employee sign off on it.
Right, and that case is that, but it's still viewed, most agencies, most courts, most arbitrators will look at progressive discipline. Listen, if you go and an employee chases after a supervisor in front of all these employees with a tire iron, you don't need to use progressive discipline. Actually, a case of ours, way back, or steals, that's a different story. But ordinarily, they want us progressive discipline. The purpose of the warning letter is to go and try to correct the situation. It's not like, oh, I heard Glenn speak about warning letters. We'll go write a warning letter Monday, Tuesday, and fire them on Wednesday. You have to give them an opportunity to prove. Yes, Josh?
Because many of the larger companies like Walmart, Home Depot, Lowe's, those kinds of companies have it in their employee manuals that first there'll be a verbal warning, then a first written, and a second written.
I hate those. To be honest with you, I would not advise that. We don't represent Walmart, but we represent some decent-sized national companies, whatever. And I'd rather have one warning letter too many than one too few. Because then the issue is, was it verbal? Did it happen? Didn't it happen? Whatever else it is.
And if you have a progressive discipline policy like that, there's just a case where the employer didn't follow it. And so they said, oh, we fired him for cursing out his supervisor and for not doing a good job, and there wasn't enough. They didn't first verbally warn him. They didn't give him a written warning. They skipped straight to suspension. And the court said, well, you didn't follow your own discipline policy, so we're going to assume that you really fired him because of his race and not because of his conduct.
I love when that happens.
Well, we'll get your cases. Okay, go ahead.
Can't you go get behind that by putting a proviso in your at-will employment stating that although the employer fully believes in policies, especially progressive discipline, is that the employee's prerogative to terminate any employee for any reason whatsoever?
Well, except that what happens is that, when you talk about at will, there's really no such thing as at will from a practical standpoint, because the employee will go file a claim based on age, race, sex, national origin, sexual orientation, religion, creed, handicap, disability, genetic predisposition, marital status, veteran status. I got most of them, but I'm just saying as an example. So that's why an employer will have to do that. When we represent companies, if companies use us right, they'll go say, hey, Jasmine, hey, Glenn, do you think this is enough? and we go say yes or no, and then we go, if we don't like firing, it costs a lot of money to go and fire people and train them. But for those that happen, we say, listen, Mr. or Ms. Investigator, CEO State Division or wherever, we didn't fire this person. Person fired themselves. Here's Exhibit A, Exhibit B, and Exhibit C. So that's what we have. Let's get back to the handbooks. Questions, somebody else? Yes, sir. 5 minutes. Gotcha. Okay. So that wasn't a question. It was a 5-minute warning. Thank you.
Let's
All right,
go
here
to
we go.
social media.
Let's take social media. Let's take the thing with. So handbooks have that. All right, Jasmine, I'm throwing this right back to you because you've done all these cases.
Okay, so social media, the test is when an employee posts something on Facebook, Twitter, wherever, the test is whether the posting was concerted, a few people, not just one person, whether the postings are protected or seeks to benefit other employees. And was there a loss of the NLRA's protection, which is if it was very malicious or reckless, is threatening violence, anything like that, then it'll lose the protection of the NLRA and it won't be, they can't go to the board. So when a posting's concerted, that could be one person posting and other coworkers making comments on Facebook. That's considered concerted. And then if it's protected activity, if they're talking about the terms and conditions of the workplace, that's considered protected. So in this case, Carl Nas Motors, an employer owned several dealerships. One was the BMW one. A salesperson at the BMW dealership was upset because there was an event and the employer decided to serve hot dogs and cookies and chips, and he thought it made it look cheap. And him and his coworkers discussed that, that may affect their commissions. They'll receive less commissions because they're going to think it's a cheap dealership. So I'm going to talk about the one that was a violation, then we can talk about the one that wasn't. So he posted on Facebook pictures from the event, and he wrote captions just saying how cheap it was, and friends and relatives commented, and so did coworkers. And that was found to be a violation by and then the employer saw and terminated the employee. The employee went to an NLRB, and it was found to be a violation of the NLRA because it was concerted. He was an employee. Other employees commented. It was protected because they were talking about it affecting their commissions, which is wages.
Non-union company, remember.
Non-union company. Mm-hmm. And it did not lose the protection because it wasn't malicious or reckless or threatened violence in any way. This employee, so the employer was found to violate the NLRA. The employee also posted pictures of an accident that had occurred a few days later where a salesperson had allowed a 13-year-old to sit in the driver's seat, cause an accident. The guy took pictures of the accident and posted it on Facebook, and other employees did comment on it, but that was not found to be a violation because he wasn't talking about protected activity with the accident. So if he had just posted on the accident and the employer terminated him, that would have been okay. But because he also posted about the cheap food and it affecting commissions, the termination was found to violate the NLRA.
And you have reinstatement and full back pay. So it's not like, okay, what's the difference?
Is this a posting on a company page or their individual
His personal Facebook.
Okay. Could be either, though. Okay, next.
There's just a few other cases, same rule. You'll have it in your packet. And if you want to talk about the...
Yeah, let's talk about, we got only a couple more minutes to go, so I want to make sure we talk about the new recent Supreme Court case. So you probably have seen this. I just want to make sure we talked about the discrimination case, very interesting case for us, and that's the Abercrombie and Fitch situation. The Supreme Court considered when an applicant must inform a prospective employer of the need for an accommodation in order to prevail under Title VII, an employer for refusal to hire in order to avoid accommodating religious practices.
So, do you want me to?
Yeah, go ahead.
So in this case, a woman applied to Abercrombie and Fitch. During her interview, she was wearing a headscarf. She's practicing Muslim and wears a headscarf for religious reasons. She was interviewed. The person who interviewed recommended her for the job, but spoke to her supervisor and said, you know, we have a no caps policy, and she's wearing a headscarf. Does that violate the policy? The policy just said no caps. It didn't have more information, so the supervisor said, yeah, I think it does, and they didn't hire this person. She sued for Title VII discrimination because of religion. The district court found in her favor. Then the employer appealed with the 10th Circuit, and the 10th Circuit reversed, saying that the employer couldn't be liable for failure to accommodate because the applicant didn't tell the employer that she needed a religious accommodation. They didn't have an actual knowledge of it. It went to the Supreme Court. The Supreme Court reversed the grant of summary judgment and remanded back to the 10th Circuit for further decision, basically saying that Title VII's disparate treatment provision doesn't impose a knowledge requirement, and they were not going to add that language to the law. So whether the employer had actual knowledge, thought it may happen, didn't know, or thought they may need to accommodate, doesn't matter. They failed to accommodate, and they didn't hire her because she would need an accommodation, so that's discrimination. The employer was in violation of Title VII.
Yeah, and to me, if somebody comes in with that, you figure as an applicant, you would figure that that person would probably have the same, need to wear that scarf for religious reasons, regardless. They're not going to go and say, "I'll come to the interview with that on," but then later on, I'm not going to necessarily have that situation. Question, yes.
I thought they also had an employee who was hired, was working with the scarf, and then got laid off.
Well, this one is just about the applicant, the EEOC Abercrombie case. And the employer also argued that it was a neutral, no caps policy, so they shouldn't be in violation of the Act. But the court said it may be a neutral policy, but even if it is, you still have to make accommodations for people.
Yes, sir.
Not of this scarf, but otherwise, is an employer obligated to provide its employees time off religious prayers, or say, for example, Muslims normally on Friday they have to go to mosque and pray 5 times a day. So is it an obligation on the part of the employer to provide that off time to its employees in form of the religious accommodation?
It depends. So to receive a religious accommodation, you have to have an actual religious belief or conviction. It can't be made up. And the employer has to accommodate it as long as it's not an undue burden on them. So that would be a test of whether it's an undue burden on the employer. Can they have somebody else work Friday easily instead of that person? Then it wouldn't be an undue burden, and they would have to provide that accommodation. They are only open on Fridays, and they only have one employee, then maybe it would be an undue burden. But that's, it's a fact-basis test, and it's not just about economic, though. The undue burden is not just economic.
Okay. We're good? All right. I think that's it. I have to say one thing. I really want to thank a tremendous amount of questions, comments. It really makes our job up here easy. We do appreciate that. Hopefully it was something that wasn't the nightmare was just the nightmare was the content and not the presenters. But we really appreciate that, and we want to thank Tom Hannock and the rest of the sponsors very much for that, Roger and the others. So thank you again.
Thank you.